us a gift for the auction. And our conference is going to be here on October 10th, 11th, and 12th here at this place. So we got a lot of things going on, and we're trying to grow our organization and reach out throughout the state. So we need your help, and anybody. We need your help promoting us, and we're trying to get the word out, but we need all the help we can get. We want to be a full state organization, and not just a limited people, but we need to get the word out. There's a lot of people that don't know about us, and there's a lot of people that need to know about us. And we'll be glad. All right, I'm going to let Glenn the Culture come up. He's going to introduce the sponsors and the speaker. Thank you.
Thank you, Richard. How was lunch? Mine was good, light. I needed that. You know, when I was asked to introduce the commercial vendor speakers today, I immediately thought of something I asked Dan Curtis, one of our founders, a year ago, or a few years ago. What is the relationship between our commercial and vendors to our membership and organization as a whole? And Dan said something then that I think is relevant today, that they are the glue that binds the membership together. And they're also the conduit which most communication occurs through. And then he paused for a minute and he said, as president, you'll also realize they're worth about 30% of your revenue for GASSA. So we thank the vendors for their support. The two that I get to introduce today, U-Haul and Marcus and Millichat. I personally benefited from their services. They have great talent, they have a deep bench, and they also have deep pockets. And we certainly appreciate that. So first, if I could invite RL to come up. JL, excuse me.
RL, JL.
To speak on behalf of you all. Thank you.
He works. After the noon. Really, plain and simple, honored to be here. U-Haul and storage go hand in hand. It's, like I said, a glue. Because if you want to make a little money on the side and help you fill out your properties, that's what we're here for. And we also have very competitive and very good prices on insurance and other stuff. But plain and simple, we love storage. We've been doing storage for a while. We also have corporate stores, of course, but we love our dealers, and we love to have y'all as part of our network. And again, it's something that y'all, truthfully, I haven't known a dealer that has storage that would not help. We did not help fill it up and make a little money on the side, which is what's important. So thank you very much, and again, we're very honored to sponsor this event.
Thank you. Did you realize you could rent a U-Haul truck at 18 years old? And a van, I think it's 16. Is it, if I'm mistaken? Well, the video surveillance has been very interesting, watching an 18 and 20-year-old back 20,000-pound vehicles into our urban loading docks. It's well worth it. Speaking of that, speaking of millennials and young people, I'm reminded when Stacy Gorman and I were invited on behalf of this association to be guest speakers at a University of Georgia graduate program, which was a very interesting experience. But about halfway through, I started to envision all these word clouds over all of those 18 and 19-year-old students' heads and said, who are these people? What are they talking about? What is self-storage? Isn't that something my parents need? But today, I listen to every word those millennials say, and I'm even paying people to learn what they're thinking about. Isn't that right, Stacey? So I'm sure you encounter that as you market some of your properties. So Stacey Gorman with Marcus from Millichat.
Thank you, Glenn. And Glenn, not only was that a great experience for us, but I continue to get interns from UGA, and I have one working for me this summer. So it's really great being able to work with colleges. I love that Raj is high school students coming in and working for him. That's awesome. So first, I want to thank everybody. I could not be standing here, I could not have this career without the support and help of the Georgia Self-Storage Association. So out of my heart, thank you all. All the members have been so supportive to me for so many years. When I started here, not knowing anything, and 15 or so years later, probably having the best year of my career in sales. And a lot of that is attributed to everybody here, so thank you. I had some stats up just to show you all how active this market is right now. Oh, okay, probably can put them up. So just some basic stats from our company as a whole for self-storage. We sold 195 storage facilities last year. What's even more amazing is it was over $1 billion, and that just goes to how valuable your storage investment is today, and definitely has increased year over year. We're getting prices that no one ever thought would be possible. We're competing on land with retailers, so we're paying more for land to develop because the self-storage industry is so profitable. Just in the last 3 months in the Southeast, we've sold 28 properties. We've had an average price of about $3 million and an average cap rate of 6.7. And that's going to be everything from, really low, below 4% lease-up properties to some of the real rural properties that are going at 10, 12%. One more slide. And so, just to give you how I've been able to do this has a lot to do with the company I work for, Marcus & Millichap. We're a national company, and we have a national platform that enables me to work with 1,700 agents nationwide. That's even more important now because we have so many people wanting to get into the self-storage industry. So though I specialize in self-storage, and about 45 of us specialize in self-storage, I have colleagues that specialize in retail or offices or apartments, hotels, medical offices, and they're all interested in self-storage now. And it's amazing how many are coming into the storage industry. And so we have these buyers that I would never have known about if I didn't work for the firm I work for. And then finally, I'd like to consider myself an advisor to all the members here. I'd like to work with you at any stage. Often I'll sell properties after I've met with you for years. I can do an opinion of value and give you some ideas of what's going to improve the value of your property so that when you are ready to sell, you'll maximize your value. So again, I just want to thank everybody. I forgot I've got some of my team members here, if they could stand up. Mike McManus, Peter Corey, and Craig Gorman. So again, thank you all. We have a drawing every meeting for a portfolio. So pull the card out there. And this is Paula Dare from Able Self-Storage.
Thank you, Stacy. And I have the pleasure to introduce our keynote speaker today. But under the leadership of Richard Williams, our president, he hit on the concept of membership, and we're in a pretty successful membership drive right now. But here's the value equation of the day if you're considering whether it's worth storing or joining the Self-Storage Association. I think the annual fee is $250. We do a show like this about 6 times a year with a keynote speaker. So you're in for about $40. Then $30 for the lunch. So you're all in for $70. So my question to you is that when have you had the opportunity to listen to a practiced, professional, entertaining attorney speak directly on the point that you're interested for $70? So if that doesn't motivate you for membership, I don't know what does. I spent $600 last week on something that I didn't really want to talk about. But, Scott, we look forward to you, and you are on the clock.
I'm not going to stand here. You guys know me well enough to know I'm going to be walking around. Let's see if we can figure out where they put my program. I'm really glad you all are here today. We have a lot to talk about. Good. And he's going to get over here soon. Let's see. All right. We're good to go. All right, so first of all, thank you all for being here. It's a good crowd. I'm glad these subpoenas worked for each of you to be here. That's always helpful, or the threat that if you're not here, I'll sue you. We have a lot to talk about, a lot's going on in the industry, but I have to do one thing first, if you'll indulge me with this one introduction, because I'm so proud of the fact that after almost 30 years in the self-storage industry, I finally be able to get a family member to join the self-storage industry. And my nephew, Devin Zucker, right there, is new to Janus. So if you have anything that you need to buy that relates to something Janus sells, go talk to him or I will sue you. I might get in trouble for that, but it's all right. All right, so look, as we've done every year that I've come and talked to you folks, this is an opportunity to get caught up on things that are going on in the industry, but also to ask questions and to learn from things that maybe you can go back and utilize in your own facilities, making sure that you are an advocate for your own properties, making sure that you're doing the right things and staying out of trouble. So let's just talk about some of the things that are happening, and hopefully if you get my monthly minute, or read Messenger or Inside Self Storage, you're seeing these articles that I've written about some of these updated legal topics. And the number one case that came out just a few months ago that everyone was waiting for was the Heckard versus A1 mini storage case out of California, which was to decide whether protection plans were insurance and therefore needed to be regulated by the insurance commissioners of, in this case, California, or whether protection plans could stand alone as a separate benefit as a tenant at a self-storage facility for which you, if you provided the protection, could be paid as the landlord and then be outside of insurance. So are any of you using protection plans now currently? Just a few. So the third-party tenant insurance program like Minico, Bader, Safe Store, all these programs that offer third-party tenant insurance have never really been challenged in the self-storage industry. You have an opportunity, and I encourage you to do this to make sure your tenants have insurance for their stored goods so that if something happens, they go to the insurance company or someone in the third party to recover in case there's loss or damage to their property and not to you to complain about. And also, by having that tenant insurance, you create some sort of liability protection for yourself in case something happens to their goods. Again, they're looking to a third-party carrier to take care of that issue. Protection plans are essentially a warranty program or a guarantee program that if something happens to your tenant's goods, they can come to you directly and you will pay them to the value of what they have paid for under the program, typically $2,000, $3,000. And the question was, is that insurance? Is it really just another name for insurance? And it could have been a very expensive lesson for self-storage operators that are using protection programs if the courts had determined that it was insurance, and in fact, they should have been paying rates to the insurance commissioners for the state of California as a result of having the program, and lots of other regulatory problems they could have had, penalties, other interest expenses, things like that, and the court found that the protection plan was not insurance. In fact, their phraseology was that the sale of the plan was incidental to the principal purpose of renting storage units, meaning it was not the business of a self-storage operator to sell protection plans, it just came as part of the rental of the spaces. And that's how they differentiated protection plans from insurance and found that it was not something that had to be regulated. Now that's going to have an impact across the country with regard to the protection plan programs that you now might be seeing more and more of, that people will start, some of the vendors will talk to you more about the attributes of their protection programs as compared to the tenant insurance programs that you have. And the primary benefit is more money in your pocket by using a protection plan, because you're not paying a third-party insurance company to deal with it, you're going to have to deal with it yourself. So those of you who have the tolerance for dealing with tenant complaints and tenant claims for loss or damage may be more interested in considering a tenant protection program. My message to you today, based upon this is the Supreme Court of California, is protection plans, in my opinion, I'll use the general phrase, are now legal. So if you were considering it, if you've talked to vendors, if you want more information about it, happy to talk to you about it, but it really was sort of the significant case in our industry with regard to these sort of questions. So that was one case that came out recently, very important, and should make you feel better if in fact you are using a protection program. ADA cases. Many of you saw this happening this summer and early spring. There were about 30 cases filed against the largest self-storage operators in the country, claiming that their websites were not accessible to the disabled because, and many of you have read these articles, because someone who was blind could not use the website. So I know there's thoughts going on here with regard to how does a blind person use a website, but in fact, the folks that are visually impaired can use a website by using a system called a screen reader, whereas they go to a website and utilize the site, that the screen reader will speak to them about the elements of the website that they are using, not seeing, but using. And in fact, the self-storage companies that were offering rent online, pay online, use our services online, were effectively offering their business with a barrier to access because they didn't have screen readers. So there were lots and lots of lawsuits. It was because of a case out in Florida that suddenly decided this was a Winn-Dixie case, where Winn-Dixie offered groceries to be delivered through an online program. You know, you could go online and click that you wanted fruits and vegetables delivered to your house. That someone that was visually impaired tried to use the Winn-Dixie site for delivery. They didn't have a screen reader. They sued Winn-Dixie, and the court found that was a violation of the American Disabilities Act. Big judgment. That same lawyer then, because they were so excited about it, sued 25 self-storage companies. And those companies were doing the same thing. Rent to own, services available online, all the things that we're offering online with the big companies. Now what happened is a lot of those companies immediately settled those cases. And unfortunately that means that the lawyers that had filed those cases in certain states all got excited about the fact that it was an easy settlement and now filed a bunch of cases. There were about 65 cases filed in New York against self-storage operators, earlier this summer, all about the same issue of screen reader violations under the Americans with Disabilities Act. It is a risk to you, the same risk that we talked about for years with regard to access to your roll-up doors, your driveways, your parking spaces. The Americans with Disabilities Act is a very tough law to comply with. It is very specific to the requirements that you need to meet the requirements of the law, and by failing to meet those requirements, it's immediately a violation of the law, entitling the people that bring the action to attorney's fees and damages for bringing the action. Now we see it in self-storage, and especially in the website issue. So if you've been working with a website developer in our industry, like the G5 or Storage Group, you've seen these advertisements come out from them which say, our sites are ADA accessible. And I really encourage you to talk to your website developers to make sure that your websites have screen reader applicability if in fact you're allowing payment online or rental online. And a lot of you have moved to an online system. Many of you are using a lot of unmanned properties with a lot of accessibility through your websites. Know that self-storage is a target for ADA violations, and that's why all of these cases came out this last year. So think about that with regard to your own websites and the applicability specifically of a screen reader to use your websites. Now, without saying anything negative about the ADA, I know that many of you are asking the same question when I talked about having accessible unit doors at your self-storage facility under the ADA, and your answer was, you've never had anyone that's disabled at your facility. Why should I have an accessible door, a roll-up door at my facility, if I've never, ever, ever had someone come to my facility that was utilizing a wheelchair? And my big legal answer is, it doesn't matter. And that's a terrible answer because it's the fact that it's the law. The law provides for the same accessibility regardless of the use or non-use. Same way I analyze it to a movie theater that has seating available for someone that's in a wheelchair spaces, but they may not use it for that movie, but it's still an allocated space for someone who's disabled. It's true for self-storage as well. So for your websites, to the extent that you have any online applicability for a customer to use your website, you're going to have to look at ADA use of it and a screen reader. So I hate to be the bearer of bad news. I have a feeling I've really bummed the group out already. Those are two cases that, you know, one's good news, one's bad news, but really be aware of what's out there. And I really want you to think about the sort of, if you're using the technology for your properties, to be updated on how that technology can impact your legal obligations. All right, let's go to the, oh, here's a joke. Wait a minute, that's our storage unit they're bidding on. That was my comic interlude for the bad news. Thank you, okay. I didn't draw that, I stole that. Let's talk about a good news story. This is out of, for those of you who are following the class actions in New Jersey against all the self-storage REITs, and those cases all dealt with violation of consumer rights in New Jersey, and all of the self-storage companies were sued for millions and millions of dollars in large class actions about the fact that their lease agreements had provisions in there that were unreasonable to consumers. And then there's a New Jersey law that says that if you have language in your rental agreements or any consumer contract which is unfair or unreasonable to the user, the consumer can sue you, and for every violation in the contract, the commercial consumer contract, that the court deems to be unreasonable, you get assessed $100. All right, so this is the lawsuit. So think about this in the context of a class action. The lawsuits against the self-storage facilities. All right, so think about this. For your rental agreements, and many of you use the Georgia Self-Storage Association certified, approved, written by a wonderful lawyer contract. Just want to make sure, okay. That's got what, 30 provisions, right? So let's say they sued claiming all 30 were in violation of the law. So that's $100 times 30, someone help me with the math. That's $3,000 per lease, per tenant of that space, per times 6 years. So the lawsuits in New Jersey on this issue, I'll use the public storage as an example, was a class action of 156,000 tenants claiming that their lease agreement with public storage was unreasonable under this law and could sue public storage for the damages. Their claim was, in that case, was close to $25 million of a lawsuit. Now, they sued CubeSmart, they sued, they didn't sue U-Haul. And I'll tell you why they didn't sue U-Haul, which is interesting, because U-Haul has an arbitration provision in their contract with a class action waiver. So U-Haul was kept out of the REIT class action lawsuits, which was pretty smart. So you actually, as a matter of fact, all the public companies, if you've seen any of the public company leases now, they all have arbitration provisions in there. That was like, well, U-Haul got away with it, we should do what U-Haul did. But so what happens, they sued for tens of millions of dollars. So I'm trying to get this right. Life Storage settled their case for $8 million. Okay. Now keep in mind, this is how class action works. The lawyer who brought the case for the class action gets like $4 million, and everybody else that's part of the class gets a coupon for $2.50. That's how the class works, right? If any of you have been in a class for all the, the things, you get nothing, but the lawyers get something. So in this case, the lawyers made most of the money. And Extra Space was sued. They settled for $5 million on their case. Now, these parties have already settled. The other REITs are out there with these big cases pending against them. And the Third Circuit, Federal Court of Appeals that applies to New Jersey, came out with a decision on the statute that the plaintiffs were using to argue their case about this unreasonableness, and said, you know what, even if a contract provision is unreasonable, unless you are truly harmed as a result of that contract, financially really harmed as a result of that contract, there's no cause of action. Which is, if you think about it, gosh, that makes a lot of sense. Why no one thought about that for the last 20 years, I don't know. And before, everybody had to pay millions of dollars in settlements. But they just came out with this decision about 2 weeks ago, which means that the REITs are now going back to the class action lawyers and basically saying, have a nice day. Because we haven't harmed anybody by our contracts. You're claiming all of our contracts are unreasonable, but no one's been harmed by it. No one's property has been sold based upon the contract. No one's been unreasonably treated as a result of the contract. No one's really suffered harm. And if someone did suffer harm, then you have to identify those specific people that were harmed, and you have to build a class out of the really harmed people, not out of the 156 that have just happened to be tenants of the facility. So this is really good news for our industry, because what this does, for those of you who I've talked to about the stress of being in a class action lawsuit, this decision says, you know what, class actions make sense if you are really harmed as a result of what's happened, not just because you're a customer at the company where they were doing business. So this is good news. So that's a good thing. I can see a few smiles. Okay. Here, just for that, I'm going to have to do this one. What's over there? guys need more cheesecake, I think. All right, one more case, and now this is a little negative here, is a case out of California and Florida dealing with your lease agreements and the fact that you are making money as a result of the sale of the insurance product that you are offering at your facility. So those of you who have tenant insurance programs or protection plans where you're working with a provider, you're making money, right? So it's a little secret. No, it's not. You're all making money on tenant insurance programs and protection plans, which is good. It helps your NOI, it helps your cap rates, it's good for liability protection, but you're also making money. In the context of your negotiation with your tenant insurance providers, we're seeing commission sharing, almost 50% minimum, if not higher, on the fees that you're generating as a result of selling tenant insurance at your facilities. And when I use the word selling tenant insurance, specifically the fact that this association changed the law in Georgia to allow you to sell tenant insurance in this state as a licensed salesman under the limited lines program, allows you to sell tenant insurance to your customers as a legal right for you to be able to do it, and your legal right to derive commission as a result of it. So for those of you who are not offering a tenant insurance program or a protection program, you're missing out. One, on the revenue side, and two, on the liability side. But if you're going to do it, this is where these cases came out. Now again, this one was against Public Storage in Florida. They settled for $5 million, another class action in Florida on this issue, is the fact that you have to disclose, or your tenant insurance provider needs to disclose in their documents, that you are getting money as a result of providing the program. So it can be in the insurance application, it can be referenced in your rental agreement, but your tenant, all they need is notice of the fact that this facility derives a fee for the sale of the tenant insurance program that we offer. That's it. So now it's not an issue of, oh, I didn't know you were making money off of me. Ooh, that was really mean that you made money off of me and didn't tell me. Now, as long as it's in the documents and disclosed in the documents, there's no liability. That's how these cases came out. So again, the lessons we learned from all these is that now, if you look at certainly the larger self-storage companies that are in the country, is they've all just changed their documents to identify the notice requirement that the court looks for to avoid any injury to your customers, to your tenants. So again, good decision. Bad for Public Storage, but who cares? No one's here for Public. Is there anyone here for Public? Yeah. It's been nice talking to you. I'm going to have to leave now. All right. Sexual harassment. All right. I did come out with an article recently, some of you may have read it, that said, it's not just in Congress or in Hollywood, it's in self-storage. And it included a couple of cases where self-storage operators did bad things with their tenants, including instead of rent, they got sex for rent. Did I do that right? Yes. Am I turning red talking about this? Okay, so that's a violation of law. The guy goes to jail. Facility gets sued. Bad. But this issue is as prevalent in self-storage as it is in any other industry. And the reality check for you guys is you have to recognize it is the hot topic for liability risk for your businesses. And you're all running businesses, and you all have employees, and to the extent that you don't think, oh, this can't happen to me, it can happen to you. And it's not just an affirmative bad behavior necessarily by you as the owner of the facility or the operator of the facility, but it's what your employees do potentially to their customers, how they treat them, how they behave, how they react to certain issues. So the answer to protect you from liability is the training that needs to go into your employees to make sure that they understand how to treat people. Now, we all believe that our parents taught us well, right? So we know how to behave. And then you see these stories and you go, I can't believe somebody would do that. And you realize that they somehow have to be reminded in the workplace what is appropriate and what's not appropriate. So it needs to be your employee policy procedures with regard to what happens if someone feels that they're harassed within the employment workplace. There needs to be training in place with respect to how they treat the customers, with regard to what's appropriate and not appropriate in the environment of a business. And there has to be discipline and a reaction to those complaints. You cannot ignore the complaints. For the companies, obviously not necessarily just self-storage, but any company where there's been a complaint upstream and ignored, the company then becomes completely complicit in the action and liable for the damages. Whereas if something happens and the company is notified and acts appropriately to stem the behavior, then the company is applauded for its appropriate reaction to the problem and the liability goes down. So you have to think about what's going on in your properties, whether your employee handbook addresses sexual harassment both in the workplace and as to how managers treat the tenants. Because it's a real issue out there. You know, I know it affects people's reactions different ways, but it's a real issue and it's a #1 issue. There are plaintiffs' lawyers out there now that all they do is advertise for "have you been harassed?" And that's the issue of, you know, what does that mean? Somehow it can be, sometimes it's provable, sometimes not provable, but it's the issue of a new cause of action out there, both in the self-storage industry and obviously a lot of other businesses. Yeah, I'm really bumming you out, sorry. Last time you asked a lawyer to talk to you. All right, one more thing, and then we'll get to the fun stuff, I promise, is a new law signed by Governor Deal just a few months ago called Ban the Box in Georgia. And what that means is if you're using an old employment application that provides, or as part of your employment interview process, where you are asking on the front end whether the person who's interviewing for the job has ever been convicted of a crime or arrested for a crime, that is now illegal in Georgia as a first-level determination of who you can hire or not hire in the state. It's called banning the box. So no longer can you use as a determination initially when people apply whether they have a criminal record at all. Because it turns out that if people have a criminal record, even if they are otherwise duly qualified for the job, it's more likely than not that they'll be passed over for that job opportunity. And there's a large class of people that have had some criminal history that are unemployed and unemployable because they're always asked that question, have you ever been convicted of a crime? And then they're immediately dismissed as terms of an opportunity for employment. So the law says you can't ask that question with regard to the initial interview. What you can do is that that person gets past that first initial interview and they go, you know, you seem like a good person. Now let's get down to the nitty-gritty, is you can ask questions that apply to the scope of their employment. For example, if they're driving to visit customers to get business, and they have a significant history of DUIs, and therefore you don't want them driving because they have a DUI history, then you could decide, well, I'm not going to hire you because I'm worried about your DUI history. So that second stage could impact your decision making, which is absolutely appropriate. It's just that you can't make a determination from the front end whether to hire someone or not simply based upon their criminal history. Now, if you have, and we've seen this, if you had resident managers that you were hiring, for those of you who still have resident managers, and the resident manager's criminal history is breaking and entering, I would strongly urge you probably to move on. Because that person then demonstrates that history, but now you've determined that as part of the second phase of the interview process. So it's a matter of sort of equality and fairness with regard to the hiring process, but it also is the law. So if you have if you guys are using old employment applications that you picked up at Office Depot a number of years ago, and the box says, have you ever been convicted of a crime, and you use that as your interview process, and the person's not hired, you can get sued because you've now used an illegal application. So just another little bit to bum you out on a Tuesday afternoon. So I have this one, nice labeling, honey. That's how my unit looks, stuff. That's how most units look that you're selling, right? Stuff, or crap, as we like to call it. Boy, I'm mean today. I didn't even realize it. All right, let's talk about best practices. So these are stories, as you can imagine, that have come in through many a phone call, many a letter, many a screaming fit of what do I do now, and I want to talk to you through some of these things. And hopefully these will be things that apply to your operations and solutions that may also apply, but I didn't get a reaction to this one. Tenant brings in furniture infested with bugs. Raise your hand if you've ever had the roach patrol at your facility. The fact that the table only with universal people worries me a little. You don't have a sign up that says, bring us your bugs. Okay, so, well, that's good. So you guys are doing well that you haven't had the problem. So, but some of you, clearly, you're doing a great job on insect protection, extermination programs in your facilities. That's great. But now a tenant brings in You know what I'm talking about, that famous mattress filled with, thank you, bugs, roaches, whatever. And now you realize, because you're getting the complaints, it's in there, he's paid his rent, and everyone knows it's infesting the units around them. What do? You don't think I have the answer, do you? Okay, so you move the stuff out of the unit into a U-Haul. Can I have the number of that U-Haul truck, though, for future reference? Thank you for offering your truck that you didn't know about. You've moved it out of the unit. Well, look, the number one thing is you're on the phone going, hey, you brought bugs into the facility, get them out, right? Your call is always first. You're documenting the effort to have the tenant fix the problem they've created. It typically is the tenant's answer, which is, not my problem, enjoy my mattress with the bugs. And then the next step is exactly what Ann says. You have to protect your property and your other tenants associated with the problem brought in by that tenant who's breached the lease. So what's your reaction? To take that stuff out. Oh, I can't touch their stuff. Well, in this case, you're going to send in an exterminator to exterminate the stuff before it's ever touched, but you're going to bomb that unit, and then you're going to remove that property from the space to avoid infestation to your other units and the remaining property. What I get is that fear factor that you guys have, and I know it's true, which is that I joke about that invisible wall as you roll up the door and the roaches are roaching, and you're like, I can't go past it. Someone said I can't go past. Isn't this good? You feel it, right? You can't go past the invisible wall. Well, yes, you can. You've got to protect your property. Go in, take pictures, have people with you, take that stuff out before your property is overwhelmed by the bug problem. All right, we're talking enough about bugs. Let's try. Tenant complains that his Wi-Fi reception is bad and their unit wants a better unit. Oh, come on. Have you had, come on, nobody? Thank you, Cliff. All right, so, all right. My unit, I can't seem, you know, the one I changed was my television reception is really bad in the space, but I had to move it to Wi-Fi. Well, what are you doing in the space that you're worried about your Wi-Fi? Well, I'm running my business out of the space, or I'm living. Come on, you know you're going to say it. Living in the space. You know, the air conditioning, I'd like it a little cooler at night, please. What do? What's that? Read on the lease. David's being very patient. All right, let's read under paragraph 6 here. This space should not be used as a residence or as a business. Okay? You've got a violation of the lease. They've come in, they've identified for you that they are in violation of the lease. Your reaction, to remind them, just like David's saying, no. I mean, if they're living there, no, get out, no. 2, if they're running a business out of the space, no. Don't run a business out of the space, maybe get out. But you have to make sure that people are not using the space, and these telltale signs of these questions are an indication that they're using the space not for the purpose intended, which is the purpose of storing dead property. Dead, not dead tenants. Just want to clarify that. Dead property. I know some of you raise your hand, yeah, I found a tenant, I know, but I don't want to talk about that yet. Stuff, not business, not businesses, not to live in. Auction customer comes back to rent again. Oh, come on, this has happened to you, hasn't this? I mean, you have thrown you have sold their stuff, or you have put them in lien, and they have now had to come and get their stuff. They're disgraced. They've bounced checks. They're the worst tenant ever, and you throw them out. And 2 months later, they come back. Hey, I'd like to rent the unit. Can I? No. Don't they have a constitutional right to be a tenant? Isn't it discriminatory to turn a tenant away from a... Nobody want to fight for the rights of a tenant? Good, because we'd be the wrong crowd if we were doing that. No, the answer is no. They have breached the lease with you before. They are not a good tenant. You have not had a good experience. I'm sorry. Go down the street to public storage. It really has been nice knowing you. I'm going to get in trouble here somehow. You have the right to pick your tenants based upon their behavior. behavior. I'm not talking about discriminatory reaction based upon protected classes. I'm talking about someone who has messed with your business and now comes back for more. Turn them away. Do not be threatened that you have to rent to someone that has caused the problem to you. All right. Tenant hangs out in your office. I love this one. I just wrote an article on this one. Won't leave, which I call the creepy tenant dude syndrome. And has any of you seen these people? I've got to see. Someone's got to raise their hand. Please. Who has a, thank you. You have a creepy tenant dude? Tell us about your creepy tenant dude.
Way back in the dark ages when I was in the store, a customer, actually, my name is Scott.
It wasn't me, I promise.
He ran a septic tank disposal company, or cleaning, whatever, a septic tank. Then he would come in, and after work, he would come in with muddy food. I hope it's mud. And he would come in and sit and talk and talk and talk. And I would try to close down my office, and I would get out of there. And I lived way back in our ages, so I'm like, this is my home, go away. You know, so.
Right. And he wouldn't go away. This is why I call him the creepy tenant dude syndrome. Anyone else has, none of you have experienced this. You have such perfect tenants. I'm going to give out awards for perfect tenants. So if you have, in future reference, if you are at your office and the tenant won't leave, what do? Do you have to be as nice as, yeah, I mean, do you have to be that nice? So your brother-in-law didn't leave, yeah, okay. So the answer is, this is your business. This is a unique business, though, because people aren't living on the property. Again, they shouldn't be. They're on the property, they're visiting their stuff because they missed their couch. Yeah, with the bugs. I mean, they missed their property. They're coming in, they're seeing their property, and they have maybe want to visit with you for a while. Okay, that's okay. But there's a point in time where you have to run your business. You can tell them to leave. If they don't leave, they become a problem. What do you have the right to do with your tenants at your self-storage facility that cause trouble? Terminate. Terminate. It's in your lease. It is a 30-day, month-to-month lease. If you are having a problem with a tenant, this is one of those things that I know worries you so much. These are 30-day, month-to-month renewable leases that you have the right to terminate at any time with notice. Terminate the lease. That tenant's not working out for you, that's causing a problem to you at your facilities, you have the right to send a notice. If they don't leave, to evict them. But tenants need to know that you run the show, that it's your property, and they don't have the right to stay if you don't want them to stay. Again, it's not based upon any discriminatory intent, it's based upon behavior that they won't meet the rules at your facility. All right, tenant asks you for help to move his couch into his truck. This is a group that really doesn't care about their tenants, I guess. The answer is no. The answer is no. You are not a moving company. You are a self-storage. May I remind you? Self-storage company. So when people expect you to be part of the moving process for the property, one, you're not insured for that. Your workers' comp may not cover it, because that's not how you're qualified to do business. So be very careful, and if you drop it, you bought it. So if you're helping them move the TV, and you drop the TV, now the claim is that you've destroyed their TV, and you have to buy them a new one. It's not the business for you to be moving their property, it's the business of you to be offering the space for storage, for them to store it on their own self-storage. All right, that's hopefully helpful. You find medical records in an abandoned unit. We've talked about this over the years. The medical record issue, or any business records of others, third parties, lawyers, firm records of its clients, accountants' records. Medical comes up seemingly a lot because you find personal information in the unit and you're dealing with a delinquent tenant or an abandoned unit, and the issue is, can I sell the unit? And the answer is consistently no. You cannot sell a unit. You cannot turn over those records to a buyer at an auction for them to have the right to go through that information and learn personal information that may be contained in the unit. So you have to go through a process, especially with medical records, where you would contact the medical board and try to have them claim the property on behalf of the doctors that are involved, or if it's a lawyer, have the state bar involved with claiming the property back before you sell it, or before you dispose of it. At the end of the day, if you have no opportunity to return the tenant's records back to the tenant or to the medical board or lawyer board or accountancy board that can control the records, you have to shred the records. That's ultimately your responsibility to make sure that they don't get into the hands of third party. So you're just, in terms of shredding the records or doing something that completely verifies by a third party their disposal is what you want to be looking at doing. All right. Tenant is spouse of an active duty service member and goes into lien status. A reminder of the Service Members Civil Relief Act, the federal law that protects not only active duty military but their spouses and dependents, that cannot be sold at a lien foreclosure for non-payment of rent, but must be sold through the courts, through due process. So that's why on your rental agreements, you have a specific provision where they must disclose and notify you if they are active duty or the spouse of an active duty member, so that you know, as indicated on your rental agreement, not to sell that person through a lien sale if they go delinquent. Now, for you to go through a lien sale process and not double check that that person is not in the military, that you've not gone through the lien, the rental agreement, or through some record in your rent process that has the red flag that says this person is active duty military, you're violating federal law. And the facilities that have sold service members by not paying attention to whether that tenant is an active duty service member, the damages are considerable. And I hate to tell you this, especially because many of you have sale and disposal insurance, it may not be covered under your policy based upon your known violation of a federal law. So be very careful about making sure as part of your checklist for selling tenants units that you go back and look to see whether they've indicated anything on their rental agreement that they're active duty military, or as part of the communication you've had with the family members or anyone else that they've not indicated that they are protected by the Service Members Civil Relief Act. Or, last but not least, since the DoD has an active duty website available to anyone to check active duty status, if you have your tenant's social security number and their name, you can go online and check as part of your lien sale process. But it's not something that can be easily overlooked. You have to make sure. Now look, if they don't disclose it to you, then you don't have to check. That's why it's in your rental agreement that they need to disclose it to you for you then to take the affirmative next step of verifying their status before you sell their goods. So be very careful about that. All right. Police visit the facility looking for a particular tenant. Now I know you've had this situation. Large police officer, we talk about they always have big guns. They come to your desk. They ask you whether John Smith is a tenant at your facility. And your answer is? Yeah. Whether he's there or not, your answer is yes. Whatever you say. Well, it's also John Smith, so that's likely, okay. So the answer is that yes, you have the right, because you own your rent roll, which contains your tenant's name and unit number, to disclose to law enforcement whether a particular person they're looking for is located at your facility. John Smith, Unit 101. For them to then go to the next level of getting a search warrant, subpoena, whatever they need to get the active records from the facility, or to go into the unit to search based on what they want to do. But the issue of having police come to your property looking for somebody, or as part of an active investigation, allows you to participate to the extent of giving limited information to help them find the tenant. Not, oh, would you like to see his file? Here. That's not what I want you to do. Or, if you want to get into his unit, I've got lock cutters right here. Come on, let's go see what's in there. That's not your job. Your job is to wait for the search warrant or subpoena. Yeah, Jim?
So if you're a private facility and you can look, get the step ladder and peek down over the mesh, if a cop shows up and that could be a drug dealer, could be stashing drugs there, is it okay for us to bring in the step ladder and say, hey, walk right up and take a look?
So that's a great question. This question is about looking over the unit based upon the facilities that are built with what I'll call the chicken wire roof that allows you to go up to the top and look in. What's amazing about that is if you can look into a unit without seeking access itself, it's called plain view. And that absolutely, they could climb up, look in, and that's part of the plain view. So that's allowed. So that explains the line of police cars at your facility that are waiting to look in. Okay, so that's absolutely fine. I think there's I know there's a case out there where the police came to a unit that they were investigating, went into an adjacent empty unit, and just by coincidence, there was a hole that they looked through, and the courts found, well, if there was a hole that they could look through, then it was plain view, and that was legal. How the hole got there is the separate question. All right. There is a bad smell coming from a unit. Never happened? No. I see a couple hands. I hate to go back to I love Ann's stories because there was a phone call once with a pallet of onions. It was a unit of onions. What is a unit of onions? How many onions will fit in a unit? Pallets and pallets of onions that were left there certainly would give out a smell. I think you actually were worried that there were really dead people in there, but the question is, okay, so you're walking by during your daily lock checks, just checking, and there is a smell coming from a unit. Let's not even say smell. How about something liquidy rolling out the door? Something that would indicate to you there's a problem with that unit. Do you just go home and not do anything? That's choice number one. That doesn't seem like that was a good answer, all right? 2, call Scott, which most of you have done. What could smell like that, Scott? I don't know. Send me the smell. Why don't you email me the smell and let me tell you what's coming out of there? Or 3, can I cut the lock and go in the unit to see what's going on? Communicate with the tenant. Mr. Tenant, there's a smell coming out of your unit, or there's ooze coming out of the unit. We need to go into the unit. Will you come down to the facility and let us in? Again, just like the first issue that you may contact the tenant and they don't care about the bugs. In this case, the tenant says, oh, I'm out of town. I can't be back for a week. And you go, well, we're going to have to do something before then. Do you have the right to go into the space? The answer is yes. You have the right to enter. It's in your rental agreement allowing you the landlord right to enter for these sort of circumstances. You have the right to cut the lock. If it's a unit full of onions, you have the right to remove them and have them disposed of. If it's something else that's hazardous dripping out of the unit, of course, you also have the right to contact the fire department or whatever else you need to do with regard to potential hazardous materials. Yeah?
What if you try and contact the tenant and you can't get in touch with them?
So here's the question, you can't even get in touch with the tenant. Do you still have the right to go in? Is that, yes. Yeah, you would communicate in your comment notes that you keep, your incident report or your report that you keep on your computer, the phone number you called, the effort to contact the tenant. I'd probably at that point, many of you have the emails now, I'd send an email. Most of you have the cell phone numbers, I would text the tenant. Text. If I got a text to my phone, your unit smells, something's going on, I think I would react based upon that ability. Do you have the right to communicate with your tenant through texting or email and all this? Phone? Yes! It's in your rental agreement. The tenant has consented to communication by texting and email and phone as part of the relationship between you and your customer. Do not hesitate to communicate with your customer that way. Can you send your lien notices by text? No. But you can communicate them concerning a problem at the facility. Yeah. Okay, so the question is, can you pass on any charges that you incur to remove the problem? And the answer is yes. Your rental agreement deals with the fact that you're able to capture the cost associated with having to clean out a unit or anything like that as contained in the rental agreement. That's why your rental agreement is so important with respect to the rights that you have as the landlord over the space. You find cremated remains. There's like nothing I can do to you guys today. I don't even hear an ooh, I don't hear an ah. Anyone ever find cremated? I've got a few cremated, So what does that say about your relationship with your loved one when you're storing them in a self-storage unit? I always have to ask that question. But all right, so you open up the unit, it's part of a lien sale, you see grandma on the shelf, and you sell her? Some of you are like, yeah. If they left it, yeah, the answer is yes, you could sell. You could sell grandma. You don't have an obligation to remove the urn from the space. But if you sell it and the bidder returns it, the high bidder returns it to you, do you have the right to pour grandma out? The answer is no. That's a violation of law. So you would have to properly handle the disposal of the cremated returns, which is commonly done through the county coroner or a local mortuary. In fact, some of the urns will identify where the body was cremated, and you'd be able to return it back for proper disposal. The answer is that there is a solution to the problems when you find these things, but the truth is whatever is in the unit has the right to be sold, but it also, there are certain things that people will return to you, and you've been in those situations, and you have the right to take them back. I mean, many of you, you've probably seen, there's like a People article, a People magazine article a number of years ago, where the medals, World War II medals, were returned as a result of a lien sale, and the operator then did everything it could through a genealogical search to find the family to return the medals, and they found the family, and they returned the medals, and they had a big story. That'd be good for press for you guys. Here's Grandma, I'm returning her to you. I'm just suggesting for your own PR opportunities. Yeah. Okay, so the point of the question is, do you have to take it back from the bidder, or can you go, no, she's yours? The answer is you can say, no, she's yours, and put that responsibility on the bidder. I take a different sort of ghosts coming to visit me sort of story, which is I'd rather take the responsibility as the storage operator if people wanted to return personal items to me like cremated returns, that I would take and properly handle the proper disposal.
Yeah, I know several managers who've had this happen across the country, and they exhausted all the resources to try to give grandma back to the family. No one would take grandma,
Yeah.
not the coroner, not the city, not the funeral home, the cremation, no family member. So to make sure you don't sleep tonight, I know of a manager who told me after all exhausting of all means, he took a bit of grandma everywhere he traveled and released her. Wow.
And I'll just leave it at that. I'll just, that manager's now serving 5 to 10, but all right, there's my information. All right, so look, this is just to get the conversation going, but I can tell you guys had too much cheesecake, so I'm hitting a wall with you. This is an opportunity for questions and things that are happening. Yes, sir.
Scott, earlier you touched on storage options as far as communications legally. You said text messages is not legal, let them know there's any status of that for auction.
Well, let me switch the comment. You can text them to let them know that their property is subject to sale. If you want to communicate with them, the sale is, next Saturday at 1 o'clock, you still have a chance to pay. You can't send the legal notice through a text service.
So the second part of the question is email in Georgia is permitted.
Email in Georgia is permitted.
You don't have to no longer in Georgia send a certified.
In Georgia, you no longer need to send a certified. If you are sending your lien notices by email in Georgia, there's a requirement, though, to make sure that that email has been received by the tenant at the email address they provided to you. So there's two ways, really, of doing that. One is primarily using a system, and some of you are using a company called ArtHost, which will verify the delivery to the email address through a verifiable program. The other is a response from the tenant to that email. I got it, go to hell, which is usually the response that I think you're going to get. That's a response. That means there's been delivery of the email. Under Georgia law, if you do not verify delivery of the email or get a response, you then must send it by verified mail, which is first-class mail with certificate of mailing. So you can try an email, but if you don't get them, then you have to go to the verified mail. And again, you can't use texting as reminders, but you just can't use it for the formal notification requirement to meet the statutory provisions of the lien sale itself. Yeah.
How long after active due does a manager continue to hold these things, or is it kind of like bankruptcy, once it's settled, then you do something else?
It's a great question. So under the Service Members Civil Relief Act, once a person is discharged from military duty, they are protected under the law for 90 days. So if you go on the record and the online service for DOD and verify that that person is no longer active duty, they will give you the active duty end date. And if you're still within those 90 days, you can't sell the tenant through a regular lien sale process. You could file suit and get a judge to give you an order to sell. That's always allowed. But you otherwise would have to wait 90 days for basically the protection period after discharge in the military. Yeah. Okay, so the question is, if you don't see it, is it there? I mean, if the tree doesn't fall, do you hear it, right, or something like that? So the answer is, I'm talking about a unit that you open up as part of a lien sale, and all it is primarily is file cabinets, and your tenant is Dr. Smith, and you open up file cabinet as part of your search, and you can tell that the records are of patients. That's your red flag. I use this example. If I was renting a space, so I'm a lawyer renting a space. Remember, never rent to lawyers. I want to make sure that's very clear. Do not call me. Do not call me and tell me that you have a tenant that's a lawyer that is negotiating the rental agreement with you. Because I will tell you very simply, because it's not discriminatory, tell him to go away. Him or her to go away. Okay. So anyway. But let's say I rented a space, and in my space, I have all my personal tax returns and all my private information, and I don't pay the rent. And it's in a box as part of my stuff. Can you sell my stuff, including my tax returns? The answer is yes, because it's my property. But if you discover as part of your inventory that it's records of a third party, business clients, patients, customers, that's where the flag goes off that you need to be protective of that information. Question?
Are there any special rules if you find out a person's incarcerated?
Incarcerated, it's a great question. So my very easy answer to someone who is in jail is too bad, so sad. Okay, in a very nice way. Boy, you're gonna hate me after this. Is only the fact that I get questions, if somebody is in jail, is that a legal defense to not paying the rent? And the answer is no. If you find someone who's incarcerated, and if they'll give you the address of the prison they're at, you can send them a copy of the letter. But don't any of you feel that you are prohibited from doing your lien sale because your tenant is in jail. That's not a defense. I mean, it is equally not a defense. You're really going to hate me after this. When they're in a coma at the hospital and they call you, I'm just making sure you're listening, and they call you and I'm in a coma, then you can't sell their stuff because they're in the hospital. That's a trick question. See, you're listening.
Scott, what if they text you?
What if they text you in a coma? Yeah. Those are not legal defenses to not paying the rent, being in prison or medical. Now, you as an operator absolutely have the right to say, in all circumstances, I want to make sure you understand your right to say, we will work with you, we will not sell your stuff, we're going to do whatever we can to work out a solution. Understanding this, that only goes so far. So many of you have called me with that frustration that, that no good deed goes unpunished. You have tried to work with the tenant. You have tried, and all they've done is take advantage of that delay and that delay. And then you say, well, now what do I do? The answer is ultimately you have the right to proceed with that enforcement of the law for that issue. Yeah?
Can you turn it over to a spouse? Or is that not legal?
Can you turn the unit over to the spouse of the incarcerated person? Okay. You cannot do anything with anyone's unit that's rented by a tenant. That tenant could assign the lease to the spouse in writing, and the spouse can accept the lease. Now, for those of you who have dealt with transfers of leases, two things can happen. One is a person could sign off that they are no longer abandoning the unit, and the spouse could come in and sign a new lease for that space. Or you can have a clean transfer document. I, John Smith, is signing the lease to Jane Smith, and then on that same document, Jane Smith, I hereby accept Unit 101 from John Smith. And now you have a new tenant. So you're not really doing anything, they are, and you're just assisting them in doing that. Yeah?
The SCRA waiver.
Yes?
Has it been tested? I mean, it feels bad saying that for service, but we want you to waive the right to service.
Right. So what we're talking about is the Service Member Civil Relief Act waiver document, which means that someone that's in the military, active duty military, can waive their protections, meaning you can sell their property through a lien sale without having to go to court if that waiver's been executed. Now the waiver itself is by itself a very specific document. It can't be part of your lease agreement. It has to be a separate document. It has to be in particular font sizes with certain headings and acknowledgments as part of the document. But if they sign that document, yes, it's been tested that if someone gives up their rights, they can't then say later on, well, I want those rights back. However, I will tell you that the motivation for someone to waive their rights in a military context is typically in exchange for a discount or consideration by you as an operator. So if you have if you're near a military base and you have tenants this way, I would say that you would offer a military discount in consideration for the waiver, and that makes that much stronger and more enforceable. Raj?
So what happens if you, I think you mentioned it, but I wasn't clear. If you do not know that that tenant is in the military and you move forward with lien sale, right? You don't ask, they don't tell, there's no...
Well, you do ask. It's in your rental agreement.
Say it's not filled in, or...
Well, if it's not filled in, I would say that's as much of an indication that they're not as if they are. I mean, if it's not filled in, if there's no affirmative action by the military person that they are seeking the protection of the law, then you're not bound to investigate every tenant to see if they're in the military. It would be an assumption that they are not. So, I mean, if someone comes to you without affirmative representation, including you call the house where the tenant's been renting, that's the address they gave you and the phone number, and the mother answers, and she says, well, he's on active duty overseas, you now know that that person is active duty. You don't say, oh, hey, I never called you. You know, you're on notice now. Yeah.
So, inside of a car that's been restored, kind of in pieces, but it's still in the car, what are the legal, do you have to put in, or?
Okay, so let's talk about cars. This is a great question. I'm glad it came up. With cars, this is unique in the element of a lien sale process because cars are titled property. So as part of your lien sale process, as part of sending the lien notice after 30 days of default, you would want to do an investigation as to who owns the vehicle and who has a secured interest in the vehicle. And you can discover that through the local DMV by taking the VIN number, maybe even through your local police officer, by the VIN number to indicate to you who the proper owner is. Now, it may be your tenant, or it may have been stolen. I mean, there's some cars that we found that have been parked in self-storage facilities that are stolen cars. And therefore, you can't have the right to sell a car that's been stolen. They would be returned back to the rightful owner. But you have an obligation in your lien notices to notify the banks that may have an interest in the vehicle or other owners. They have the right to repossess the vehicle if they want before it's sold. After that, then you can go through a process. In Georgia, you have two options. One is to then go through the lien sale of the vehicle, which allows you to obtain a title for the vehicle and sell it at market value to a buyer, to then recoup that money as part of your lost rent. You can sell it at a lien sale. Your other option is after 60 days of delinquency to contact a local towing company, a licensed towing company, to tow the vehicle away and to let them deal with the problem later. So you have two options. After 60 days of default, you can go ahead and sell it, or you can go ahead and have it towed. Now, your description of a vehicle that's in parts still would require you to do the VIN search, but when you sell it, you likely could sell it for parts only, no title transferred, and not have to go through the title paperwork to get the title. You could sell it for parts. If they want later on to go get title, then they can go ahead and apply for the title after they've gone and bought the parts.
What would it be considered parts versus, would it have to run or be capable of running?
Well, one is you don't have to deal with title if the vehicle is more than 15 years old. So if more than 15 years old, it can be sold for parts only. And then if it's in a non-drivable situation, then you can sell it for parts only.
But you still have to do the VIN.
Still always have to do the VIN. Yeah, see, because again, it may be stolen, or a bank may want to repossess it. Likely not, but that's always the option. Yes, sir.
So if the bank recovers it, then do you have any recourse for recovering your losses?
Okay, so here's a great question. Well, and this is true whether it's towed away, or the bank comes to repossess it, or whatever. You now have the car or the boat, or this is true for rent-to-own companies when they come back and take the couch and the chair and the electronics away because they have a lien on it as the rent-to-own company. You're waving goodbye to the furniture or the car or the boat. You're waving goodbye, but you're not waving goodbye to the debt. You're waving goodbye to the collateral for the debt. So in this case, where they've repossessed the car or taken back the property, yes, you've lost the ability to sell property to recover the rent, but you still have the debt that's owed. So you can go to a collection agency, you can sue them in small claims court yourself. I will tell you, and I have some information on it, I'm glad you brought it up, that in the self-storage industry now, you cannot, unless you're going through a collection agency, you cannot submit it to the Credit Reporting Bureau as a trade line debt. you have to go through a collection agency. The Self-Storage Association is working now on an opportunity for you to be able to submit these debts directly to a credit reporting agency so that the tenant's credit would be affected, and therefore they would, to cure their credit, would come back and pay you to get a clean letter on the debt. So don't worry about sometimes when the property goes away, the debt doesn't go away. Including, one last thing, is the fact that if a tenant comes to you and says, I just don't have the money, I just want my stuff, do you have the right to let them have their stuff? Yeah, you have the right. You can say, come and take it. And then you still keep that debt. So you can still collect the debt, whether you will in the future or not, but you have the right to collect the debt different from the collateral. Statute of limitations, 6 years in Georgia on a contract violation, like self-storage. Ann?
Okay, a lot of wonderful vendors in our industry are coming out with electronic locks. Does it or does it not create bail?
Great question. So, and I'll press the Secure Guard, Janice, because I've looked into it, is understanding that the ability to electronically control the lock, once it's been turned over to the tenant to provide that mechanism, puts it in their responsibility to control access by being provided that service. But the key to it is the notice in the rental agreement regarding the uniqueness of the system, that the tenant must understand that he's being provided this technology for access, and they still have control over their property, care, custody, control over their property. So one of the things you have to realize is we've moved along with technology in our industry, and the laws have not necessarily kept up to the technology, but they're getting there. So before, we were all worried about electronic contracting and electronic signatures. That's completely legal. You don't need a pen or pencil signature on a rental agreement to be legit. The same way now, if there's a technological way to lock a unit, as long as that tenant then assumes the obligation of that control as part of the system, they've taken the care, custody, control of their unit. So whether it's a lock, the old days of how we're used to a lock, or an electronic lock, it's still a lock. And it's still then, therefore, their responsibility to maintain care, custody, and control of their property. But it needs to be addressed in the documents with the tenant. That's a great question. Yeah, gentlemen, and then I'm going to finish up. Yep.
So I noticed CubeSmart, everybody doing these digital signatures, but one of the things in their lease, the digital lease, and it references policies and procedures. If you click on that policies and procedures, it takes you to a website, right? So you're signing on that lease that you will, uphold those policies and procedures, which may or may not be updated at any point in time. But it's referencing. Can you go through kind of?
So it's a great question. So this is technology at its best. It's called, when you go to another site to review terms and conditions, it's called a click wrap, or I guess a round wrap. Is if it comes out and you have to manually scroll through it to then click I accept, there's an indication by the physical action of moving the scroll down that you have read it. And we're all guilty of this. I mean, all of us that do anything online that never read those terms and conditions, but scroll through it, bringing the method down to a final, I've read through it, I agree to all terms and conditions, you're toast. We're all toast. I mean, you've deemed to have read and understood it. If it's just a reference and there's no methodology for you to scroll through it, which is a problem with some of these systems that doesn't have you scroll through the system, there's an argument that you did not read it all, that you didn't have an opportunity to read it all, and that's what's in litigation now, is the method of presentation of those terms and conditions. So if you're working with a website developer and you have the ability to read your rules of the facility, make sure it's in a system that's, I guess again, a click wrap process where you have to scroll through before you can accept it, if that makes sense. Yeah. So that's how they're getting away with it. I would imagine that CubeSmart, they're smart enough to do this, would have a click wrap process. If not, then we'll talk later about a lawsuit. Yeah, I'm not that crazy. All right, one last one. Oh, back there. I'll be around for afterwards. One last question. Yep.
You talked
talked a little bit about the contents protection court case, and I recently was reading the Georgia statute on storage. It seems to me that the storage contract is basically in the Georgia statute. Is that more or less the case?
Yes, yeah, it is one of those states where a lot of the language is required to be in the rental agreement.
And you may have just helped me answer the question. We have some verbiage that we kind of drop in for contents protection, and I'm a little anxious about exactly how to get the right contents protection language into the contract without overly messing with the statute language, because there's some cross-referencing there that needs to happen.
Well, if you stayed at a Holiday Inn, you can write it yourself.
Holiday Inn Express.
But, or you can pay Glenn, and Glenn can do it. The answer to the question is there's an insurance provision in your rental agreement which requires your tenants to have protection or insurance for their property. What you can identify as an additional provision to that section is in lieu of insurance, the tenant can participate in the protection program being offered by the facility, and that's where that language would go. You would include as an opt-in under the insurance section of your rental agreement. So you're not messing with the statutory language, you're just adding language as an alternative option for the tenant.
So in my unsophisticated brain, I'm providing statutory language, and then I'm saying, or you can opt out of the Georgia statute.
Well, you're not really opting out of the statute, it's an alternative to meet the requirements of the statute. That's all it is.
And that's my privilege as the owner.
That's your privilege. As long as you make something available to your customer to meet the requirements, and you're saying the protection program is equivalent to the tenant insurance program, you've met your standard. Okay. All right, so guys, as you see up here, please reach out to me. Many of you do. If you have questions, please feel free to email me. I hope this opens up your mind to at least ask some questions when you go back to your own facilities as to things you're doing, policy procedures you might want to go back and check just to stay legal and to stay out of trouble. Richard? Oh, I'm sorry. So Richard, one other question on ADA in North Carolina. This doesn't affect self-storage in Georgia yet. We are fighting it on behalf of the National Self-Storage Association, this particular issue. The fire marshals and ADA compliance requirements in North Carolina would have said under the roll-up door requirements that we have, a certain number of units that have to be ADA accessible, that it is insufficient for them to be handles to roll the door up and to roll the door down. But in North Carolina, they must be electric door openers, like garage door openers, which has been a significant cost impact to developers in North Carolina, which are now having to retrofit their units to have electric door operators to open and close those doors. That's not yet in Georgia. Many of you who are developing here would find that your local code official is satisfied with your roll-up doors with your handles. But be worried about the fact that that might be something that you're challenged with here, and you can fight back based upon, it's the only state so far that has that requirement.
We ran into that in North Carolina, and we were able to get by with putting intercoms at the handicap units. Oh,
so intercoms to contact the manager to allow them to open the unit for them? Oh, great solution. There is a certain percentage. The scoping requirements for self-storage ADA doors are 5% of the first 200 doors, 5% of the first 200, which means 10, and then 2% of all the doors you have after 200. So let's see, if 200, you have 600 units, that's another 400 units, 2% of those 400 units, which is another 8 doors. So you'd have a total of 18 doors that would have to be ADA accessible. So the question is, can they all be the smaller doors? The answer is no. They have to be dispersed among classes of your units. So you would have your ADA accessible units and your 5x5s, your 5x10s, a 10x20, a 20x30, whatever it may be. So it's among the dispersed classes of units that you have at your facility. If any of you need information on the ADA compliance issue, I have a handout that I can email you that talks through the construction issues. And guys, the truth is, look, if you go online, and many of you have seen this through the Self-Storage Association and their publications, a lot of your questions and concerns are already included in the books that have been published by the Self-Storage Association, either my legal topics books or Q&A books that are available to you without being a member of the National Association. You may want to go onto the selfstorage.org website and look under the publications and have that as a resource for yourselves or your managers for future reference, as well as the form books that are available to you. So with that, go forth, be legal, be safe. Thanks very much.
Oh, Dan's gonna, I'm sorry, Dan's gonna do our closing. Where we adjourn.
Well, thanks, Scott, again for informative and entertaining discussion. I think he's going to have to retitle it, though. It seems to me that it should read, "It Can Happen to You." If you've noticed, and I have through the years, Scott talks about cases in California, Florida, New Jersey, and not much in Atlanta, but Atlanta is coming, and so we have to protect ourselves, that's for sure. One thing I'd like to say in closing too, is this type of meeting is why we're all members of this association. And next month, or the month after that, whatever the next meeting is, I'd like for all the members to bring somebody who might be a potential member, who's missing out on this, because we all need to run our businesses in the best possible way. And the way you get it is by information that you pick up here at these meetings. So have a safe trip home, and thanks again for attending.